Welcome back to Business Law course. This is the continuation on topic intellectual property law, and specifically we will move from the copyright discussion to the patent discussion. This is the first part of the patent discussion topic, and in the beginning we will talk about the concept and the definition of patent. As usual, to help you in the process of the studying, you are required to also open the regulation regarding patent in Indonesia, and the legal basis of the patent regulation in Indonesia is law or Act number 13 2016 concerning on the patent. This is all you need to read to learn patent at the first step. Besides the related regulation, having a book reference regarding patent or intellectual property would also help you to understand about the patent law. Well, patent is one of intellectual property that is exists in Indonesia as well as international. However, some people, especially in Indonesia, used to get it wrong or misconcepted in understanding pattern, because in my experience too, some of my colleges, some of the people I know, they asked me, for example, how to patent my song, they said. Well, that is wrong, because there is no patent in a song. At the previous topic we concerned about copyright. So when the creation is in the form of artistic works or literary or scientific, like a book, there is no patent there. Your intellectual property in that kind of form of creation is protected by intellectual property law, but it's not protected by patent, but it's protected by copyright. So patent used to be considered as intellectual property itself, while actually patent is only one of the classification of intellectual property. Or maybe you are a businessman and then you have a trademark and you are wondering how to patent my trademark. Oh, that's wrong, that's a mistake. There's no patent in a trademark. Trademark is also an intellectual property, but it's different to patent or the copyright, because trademark is focused on the unique symbol, unique logo, unique representation of a business, to make the one product or one company is different to another one. So what is a patent actually? If at the previous meeting we talk about the copyright, we already make a limitation that actually copyright is only protect the creation in territory of artistic work, scientific work, or literary works. Besides that, there are still more creation in this world, but not all of the creation is protected by a copyright. Some of them is protected by a patent. One keyword for you to understand and to distinguish between patent and copyright: patent is focused on the protection for a creation in the side, in the scope of technology. That's the keyword. Technology. What is technology for you? Technology is everything that could help the human's life. It's not always talking about a big machine or a car, an aeroplane, even though most of them are also involved in patent, but it's also including the clip paper or another small stuff, as long as it could help the human's activities. It's technology. It's protected by patent. While patent itself is exclusive right. So patent is a right. So it's also a mistake when people in Indonesia especially they call it hak patent. It's wrong. Why? Because the word patent itself it means right. So you don't have to repeat it become hak patent. You only have to say patent or patent because patent itself is a right. While the things that protected by the patent is an invention. Just like in copyright, the right called copyright, the one that protected by the copyright called a work or a creation. So in copyright you still have to mention the name right because it's the name copyright. But in patent, only by mention the word patent it means a right. So it's an exclusive right, just like a copyright. Exclusive means who create the creation or the invention here would have the exclusive authority upon the creation. It means that the one would be authorized to use the creation or to let others to use it. Before we continue further, here you could also find some terminology to distinguish it with copyright. In copyright, the right called copyright. In patent, we call it patent. No patent right, only patent. In copyright, the one who create the creation that protected by copyright, we call it author or creator. While the object or the goods, we call it work or creation. But in patent, we call the person who create the work inventor. In Indonesia, we call it penemu. While the object, the things that invented, we call it invention. So patent based on Indonesian terminology and also international regulation is exclusive right for inventor for their invention. So it was started with the existence of an inventor. Inventor could be someone who has capability in making something new. Usually they could be engineer or other people with that qualification. Based on Indonesian law, for example, inventor could be considered as a person or some person that simultaneously or personally, individually, uh, conducting their idea that is formed into a kind of activity that could gain invention. So they create some technology, the technology called invention. That invention uh, then need to be protected because the inventor already spent money, time, energy to create the things. So the patent is exists as a right that is given to the inventor as an incentive and appreciation for them to has total authority or exclusive right upon the invention for a certain duration of the time. But remember, just like copyright, you could check in the regulation, there is limitation of ownership. After a certain time, in this case in patent it's sometimes 10 years, sometimes 20 years, it depends on the classification of the patent. After the time is passed, then the patent become public domain, which means everybody could use it without any license. Just like in copyright. In copyright, some creation protected for 50 years after the passing of the owner. Some creation is 75 years. You should read the regulation to know about that. So that is an incentive. But the protection of intellectual property has a bigger idea, is to give or develop the prosperity of human's life. So after a certain times, after the incentives been given, the exclusivity is given to the inventor, then the creation or the invention would be owned by everybody, so everybody could have it. One of the famous inventor you might recognize, Thomas Alva Edison. He's the one who created the lamp that used by everybody nowadays. The existence of today's lamp is based on the first idea of Thomas Alva Edison. So he created, so this technology he made gave him protection to has total authority upon the creation, so he can use it and produce it by himself, or he could give it to the other party. So here I hope you understand the difference between patent and the copyright. And the patent is talking about technology. Technology could mean many things, as long as it's useful for the human's life. um, Motorcycle, at once it was invented, it was also has patent in the motorcycle, but after uh, several years, then the invention of the motorcycle become the public domain. Everybody can produce a motorcycle, something like that. And also you can take a look at uh, your your goods in the house. There are so many things that was protected by a patent, or even now still protected by a patent. Understanding this main concept would give you a better understanding, especially to see the position or the existence of technology and invention as an intellectual property. And at the next part, we will deepen the understanding about who is or who are inventor, as well as the invention. Thank you.